Dolly friends. This is Kitty.
And I'm Totty.
And welcome to Little Bottle Nursery. Our channel is dedicated to our love of dolls and creating fun and positivity in the doll hobby. So stick around and have some dolly fun. Hi Dolly friends, it's Kitty. Welcome back to those who've already watched part 2 of this video series. If you haven't watched part 1 or 2 yet, I've included a link in the description box below and encourage you to watch it first so that you have some context for what this video is all about, which is part 3. In this 3-part series, I've been addressing an interesting dolly topic and sharing some really valuable information about manufacturing in China, specifically what intellectual property protections and contract agreements are essential to protect an individual's work when they engage with a Chinese factory to manufacture their products. I've also been addressing how manufacturers get away with copying someone else's idea or product and the preventable measures to reduce the risk. 3 separate videos cover this topic. This is video number 3 or part 3, and there is also a link to part 1 and 2 in the description box below. I will place up on screen the discussion points covered in all 3 videos. Part 1 was essentially an introduction video where I raised certain issues in a broad context, and then in subsequent videos I have drilled down with a lot more specific information. In part 1 and 2, I have already addressed what intellectual property protections are required when manufacturing in a foreign country like China. In this video, I will be discussing what type of contract agreements can protect an idea or prototype when engaging a foreign manufacturer in China. Whilst I'm chatting, I'll do some quick outfit changes on some of the dollies in our nursery. For those who are new here today, my daughter and I collect all kinds of different dolls. So during this video series, you might see some vintage dolls, factory dolls from companies like Ashton Drake Galleries or Paradise Galleries, Reborn dolls, Gott's dolls, or even Barbie dolls. Autumn has arrived in Australia, so we are changing some of our dolly crew into some warmer clothes. Please note that in the description box of this video, I have included various credible links to support the information that I'm sharing with you, and I encourage you to click on those links and read the information for yourself so that you can see it supports the points in my discussion. And there are timestamps available in the description box below should you wish to go straight to any specific topic. So let's get started. So for any viewers who are diving straight into this part 3 video without seeing part 1 or 2, I will just take a brief moment to briefly touch on some points. So in part 1, I discussed why I made the decision to create these series of videos. It was after recently seeing some very alarming comments made online by a couple of sculpt artists who claimed that they had never put any contract arrangements in place with their manufacturers when they had their sculpts manufactured into kits. There were also some comments made about how many sculpt artists use the same factory and that many of their kits had been copied at least once. So it was fairly obvious to me that it would be worthwhile sharing some useful information about intellectual property and manufacturing agreements to educate the community about the potential pitfalls of manufacturing in China, especially when individuals have not registered their intellectual property in China and do not have a manufacturing agreement in place with their factory. It won't surprise me in the slightest if I cop a bit of flack from the doll police, who are usually the first to whinge the loudest when anyone in the doll community dares to do or say anything that they don't agree with. Honestly, I couldn't care less if it means with putting up with a bit of unwarranted hate, because I choose to share useful information that is actually going to help others from having their work copied. I'm so totally okay with that. So I'm going to start with a disclaimer that not all Chinese manufacturers are dishonest, and if there are any sculpt artists who have not signed contracts with their Chinese manufacturer and they've not had their work copied, then they should count themselves as the lucky ones, because the culture of doing business in Asian countries, particularly China, is very different to many Western parts of the world. During this series, I have identified many pitfalls of manufacturing in China, which is well documented, especially online. And I encourage you to take a look in the description box below at some of the online links I have provided that supports the information that I discuss in this video series. And I also encourage you to do your own research. So, how can manufacturing companies in China legally copy their clients' products? I have seen this question raised in our community quite a number of times, and the answer may surprise you. So, whilst I'm discussing the answers to this question, I will address some of the information contained in an article that Stephanie from N Love Reborns 2011 shared on her online community platform recently, as it specifically relates to my discussion that intellectual property protections and contract agreements are absolutely essential when manufacturing in Asia, particularly China. Back in the part 1 video, I discussed how Stephanie received a lot of hate from certain individuals in the reborn community when she recently uploaded some videos raising questions about stolen kits and Chinese contracts. There was also some discussion circulating amongst certain community members that apparently Stephanie has no idea what she's talking about. So I will address what I know about the online source she provided on her online platform. So the article that Stephanie shared, I will place a picture up on the screen and I will include a link to it in the description box below. It's a credible source and it's written by a lawyer, Dan Harris, whose work is internationally regarded. I am familiar with Mr. Harris's work and have an appreciation for his ability to write about quite complex legal topics relating to manufacturing in China and addressing the many pitfalls in layman's terms. His advice is very easy to understand and it lines up with the advice that I have previously shared on our channel from IP Australia and Austrade. Mr. Harris wrote an article in December 2020 and it's titled, "It's perfectly legal for your Chinese manufacturer to copy your products." Now, I can assure you the article title is not clickbait, and I encourage viewers to take a look at Mr. Harris's article and his other work. It truly is an eye-opener. I have provided the link to his article in the description box below, as well as a podcast interview, and I encourage you to access them so that you can gain an understanding of the complexities of manufacturing in foreign countries like China. Dan Harris is a credible source. He has an impressive CV. He is the founder of Harris Bricken, an international law firm which has various offices around the world, and they are a leading name in international law and intellectual property law. Mr. Harris is a highly qualified individual and has been awarded the rare honour of being designated a super lawyer and is well regarded for his expertise with helping companies, countries and individuals navigate foreign legal issues. In addition to his law firm work, he is both a writer and a speaker on doing business in Asia. He most commonly speaks on international law with a focus on protecting businesses in their foreign operations and is the lead writer of an award-winning China blog. This blog is regarded as one of the best law blogs on the web today. His interviews and articles regarding the various aspects of his international law practice have also been published in many publications, including Forbes magazine, Fortune magazine, magazine, the Wall Street Journal, and the National Law Journal, to name just a few. Mr. Harris also previously testified at the 2015 Commission's hearing on the Foreign Investment Climate China, present challenges and potential for reform. So in a nutshell, both Mr. Harris and his articles are credible sources. Mr. Harris's law firm receives a steady stream of clients, not just from the US, but from all around the world, from Europe, Australia, Brazil, Mexico, etc., from businesses who are seeking help with recovering their intellectual property rights that have been taken by their Asian manufacturers. Typically, they receive emails from business entities who have had their Chinese manufacturer sell their products to others, and they want advice about how to sue their Chinese manufacturer. In the article, Mr. Harris states that his law firm's first response is to ask, do you have a written contract or anything else in writing forbidding your Chinese manufacturer from copying your products? In nearly all cases, none of them have anything in writing, so then his law firm gives them the bad news. Without anything in writing, the law firm would tell them that they were not interested in suing the Chinese companies. One email expressed surprise at what their Chinese manufacturers were doing to them, to which the law firm's response was, quote, if your Chinese factory were not stealing your designs and using your name, I would have been surprised. Truth is, they do that pretty much every time, and it's perfectly legal unless you have a contract for intellectual property registrations that prevents it. So what this basically means is that when manufacturing in China, if an individual has not registered their intellectual property in China or have written agreements in place with their Chinese manufacturer stating in clear terms that they own the intellectual property on their finished or final product, it is extremely difficult for the individual to prove to the Chinese courts that they own the intellectual property for their product. This law firm advises clients who find themselves in this situation to find a new factory, because as soon as the manufacturer is making sales off their client's product, they are a nuisance to them. At this point, Chinese manufacturers are well known for increasing their clients' factory prices so that they are no longer a competitor to the product they are selling, which was once the client's product, or they will simply refuse to continue making the client's product. So this article confirms what I've been discussing in previous videos on our channel. Individuals need to register their intellectual property protections in China, as well as written contracts to protect their work from their Chinese manufacturers. I realise this might sound harsh and unfair, but it's simply the reality of doing business and engaging with the manufacturing industry in China, or anywhere else in the world for that matter. It doesn't matter which manufacturing industry individuals use, they will always need to protect their ideas and work. And the only sensible way this can be effectively done is with proper legal assistance from a reputable law practice who specialises specifically in intellectual property law and international law. So before I go on to discuss the different manufacturing stages and contract agreements, I want to note that not all Chinese manufacturers are dishonest. In addition, there may also be situations where individuals may put all the legal protections in place to protect their work, and it will still get copied by their manufacturer or from outside the supply chain. However, with the right global intellectual property protections and contracts in place, individuals are more likely to have a successful outcome. When you hear of individuals winning their case against a Chinese manufacturer, it's because they have very likely registered their intellectual property, not only in their own country, but in the countries where they manufacture and sell their products, as well as having the appropriate signed contract agreements in place with their manufacturer to protect their intellectual property of their final product. The courts recognise this and have made their decisions in favour of the individual based on intellectual property merits. So although legal tools are an investment, they may not always be 100% effective, but they will be helpful at one point if an individual's product is successful. Individuals need to be wise and identify the highest risks and work out with their law team how best to mitigate them. Smaller businesses should not ignore the need for legal tools, as they actually need contracts more so than bigger businesses. Think about it, Mattel, they're maybe a $50 million client. They're more likely to have their manufacturer listen to their needs than a small individual or business entity. So when an individual has a completed idea or prototype and they are ready to find a suitable manufacturer to produce their product, it's important that they take off their creative hat and replace it with their business hat. Individuals are about to venture into the highly competitive world of business and manufacturing, where their competitors are aggressively waiting to push them out of the market. Before talking about the specifics of contract agreements, I want to touch on 3 to 4 main issues that are current in China, which reinforces why it is so important for individuals engaging with Chinese manufacturers to have the correct intellectual property protections and contract agreements in place. In recent years, there's been a huge increase with certain Chinese manufacturers setting really low prices to attract new customers, and unfortunately their intentions are to get their hands on their clients' products so that they can start manufacturing and selling the product as their own. If the manufacturing price is too good to be true, individuals can potentially be dealing with a manufacturer that just wants to take their product. Intellectual property theft is on the rise in China at the moment, particularly with trademarks. Although the Chinese government enacted law making it illegal for manufacturers to take brand names from its own customers, Chinese manufacturers have found loopholes to get around this law. Bad faith registrations occur when a manufacturer asks a relative or a subcontractor in another Chinese district to register their client's intellectual property, including their brand name, product name, or logo as its own trademark. This practice makes it nearly impossible for individuals or business entities to invalidate the intellectual property. China works on a first-to-file system in their country, which means they will not recognise intellectual property used in other foreign countries first. Once a manufacturer registers their client's trademark in China as their own, they have the power to stop their client's goods from leaving China because they legally own the client's trademark or other intellectual property rights. This is why it is so important for individuals to register their trademarks and other intellectual property rights well before approaching any Chinese manufacturers. Some manufacturers may wait years before asserting their rights on what was once their client's product, and this generally happens when a client changes factory or there is a sudden interest, like a re-interest in a product. There are some very important points to take from these main issues in China. Individuals and business entities will need to seek professional legal assistance with conducting due diligence reporting to ensure they engage with a reputable manufacturer. Individuals will need to register the appropriate intellectual property rights and protections, including a China trademark, to prevent their Chinese manufacturer from taking their brand name or other intellectual property. It is very important for individuals who plan to put their brand or product name on their product or their logo on their product or packaging to register those as trademarks. This should be done even if they're not going to be selling their products in China. An individual's brand name, their product name and logo are their most valuable assets. In China, the first to file a trademark is awarded that trademark, so it does not matter if an individual has registered it first outside of China. Therefore, if a Chinese company registers an individual's trademark in China, because the individual has neglected to do so, the individual will be at risk of having their products detained at borders for violating the trademark of the Chinese company. Individuals will need to ensure they had the appropriate contract agreements with the manufacturing company to protect their intellectual property, not only during the manufacturing process, but to also prevent their manufacturer from selling their work to third parties. I'm going to address this issue with third parties later in this video. I have already addressed the topic of intellectual property in great detail in part 2, so I will keep this relatively brief. Well before an individual has selected a Chinese manufacturer, the law firm working on behalf of the individual will commence registering the intellectual property rights in China. With the exception of artistic works, intellectual property rights and protections are not universal and can vary from one country to another. The protections for artistic works under the Berne Convention have limitations, and I have detailed those limitations in the part 1 and 2 videos. Although countries around the world sign up to various treaties and conventions like the Berne Convention, countries still operate under their own set of laws, which foreign individuals and business entities need to comply with. Copyright and all other intellectual property, including trademarks, should be formally registered in China if individuals plan to manufacture in China, because this enables them to have their intellectual property recognised in the Chinese court system, which then enables enforcements on infringements. So now I will move on to discussing the main types of due diligence and contract agreements individuals can put in place when engaging their Chinese manufacturer. I will speak in general terms, as each individual may have specific needs to suit their own circumstances, which their law firm will counsel them on. I am placing up on the screen the types of information that is included in a due diligence report. Before an individual engages the services of a foreign manufacturing company in China, the first step they need to take is seeking legal counsel from an appropriate law firm that can conduct the relevant due diligence checks on factories manufacturing in China to ensure the individual is choosing their manufacturer wisely. The law firm will conduct background checking on manufacturers and prepare a report with a wide range of information. This information should help individuals select the most reputable manufacturer. Getting this stage of the process correct is so important for an individual or small business, because about 30 to 40% of the time, well-researched due diligence reports will be enough to determine who not to use as a manufacturer. Before an individual hands over their idea or prototype to their factory, their law firm should draft up contracts, which is an essential step in protecting the individual's work. In China, the purpose of having a contract is to protect an individual's design, whereas a Chinese trademark protects the individual's brand name. A trademark is the most valuable asset anyone can have, which I will also discuss in this video. Contracts and intellectual property go hand in hand with manufacturing, so during this video I will also be briefly recapping on a little bit of intellectual property, as it's already been discussed in length in the previous 2 videos. Contracts are essential when engaging with a Chinese manufacturer because they provide clarity, prevention and enforcement. China operates under a legal system that if it's not listed in the contract, it does not exist. For example, if a Chinese manufacturer sends a fabric sample to their client in the colour duck egg blue, but there are no provisions in the contract stating that the product needs to be manufactured in duck egg blue, then the Chinese manufacturer can legally produce the product in any shade of blue or any other colour for that matter. Another point worth mentioning is that for contracts to be recognised in the Chinese courts, they should be in dual language, so in English and Chinese. Intellectual property also needs to be registered in both English and Chinese spellings. So starting with the first type of agreement, an NNN agreement. Under no circumstances should individuals reveal confidential information to their manufacturer without an NNN agreement, which stands for non-use, non-disclosure and non-circumvention. NDA agreements have no value in China as their purpose is to protect trade secrets from the public. Individuals do not need protection from disclosure to the general public because Chinese manufacturers have no intentions of revealing it to the public. NNN agreements that are done properly are flawless, and they are the key to protecting individuals' intellectual property against their manufacturer because it prevents their manufacturer from copying the individual's idea or prototype for their own benefit. When the manufacturer signs a properly executed NNN agreement, they are legally agreeing not to use their client's idea or prototype in competition against the client, and if they do, they are in breach of their contract. Financial penalties should be included in NNN agreements. These type of agreements also prevent the manufacturer from sharing the client's idea or prototype with any of their family companies or subcontractors, or selling their client's product at 50% less than what their client charges. NNN agreements need to be written in a way that Chinese manufacturing companies fear breaching their agreement because they will be substantially financially impacted for not complying with their contract. Another important note, many foreign laws are not recognised in China, so NNN agreements need to be written with Chinese law as the governing law. The courts also prefer to see contracts written in Chinese. The next stage is the product development stage, which is the highest risk stage for individuals manufacturing in China. Therefore, individuals should carefully consider having a product development agreement in place with their manufacturer. A well-written product development agreement should cover the period between the NNN agreement stage, when the individual is deciding which manufacturer to use, and the manufacturing agreement stage, when the individual has selected the manufacturer and knows what will be manufactured. An idea or prototype may need further development or refinement before large-scale manufacturing can commence. When overseas manufacturers in China even slightly modify their clients' products, it raises legal questions such as, does the individual, the client, own the rights to the modifications? Will the individual, the client, own the intellectual property rights to the final product? A well-written product development agreement includes things like provisions for the product to be developed, timeframes, the technology, the individual and the Chinese manufacturer will contribute, details of who will provide specifications, and most importantly, who will own the intellectual property rights for the end product, for the final or finished product. If no formal product development agreement is signed by both parties, it can become very unclear legally who owns the intellectual property rights of the final product. It is also not uncommon for individuals to unintentionally relinquish their intellectual property rights to their Chinese manufacturer. Individuals will be in an unfavourable position if their Chinese manufacturer did the development work and produced the moulds and toolings at its own cost. Chinese manufacturers and Chinese-owned factories in other parts of Asia, like Vietnam and Thailand, often prefer to cover all product development costs because they want to own the end product. Individuals far too often go along with this not realising that the Chinese manufacturer will end up owning their product and its related intellectual property. When the manufacturer has asserted it owns the intellectual property rights in the developed product, they will make their product available to the client while at the same time manufacturing what was originally the client's product for their own sales under their own trademark and making the product to sell to their client's competitors. Because there is no written agreement clearly stating who owns the intellectual property of the end product, Chinese manufacturers are justified in claiming intellectual property ownership because they have contributed their technology to developing the product and incurred the product development costs, e.g. making the mouldings and toolings. It's not uncommon for Chinese manufacturers to wait years before asserting their rights on what was their client's product, and this commonly happens when the client decides to move their business to another manufacturer or if there's a sudden re-interest in a product. So, in a nutshell, individuals will find themselves in a really unfavourable position if their Chinese manufacturer did the development work for their prototype, even minor changes, and produced the moulds and toolings at its own cost. If individuals own the moulds and toolings, then they need to make sure that there is a signed product development agreement or a mould agreement stating as such, plus any penalties should their Chinese manufacturer not immediately return these items to them after manufacturing is completed. A reputable law firm can assist individuals in determining who owns the intellectual property for the end product and can draw up agreements accordingly. Without the correct agreements in place, individuals can find themselves in a position where if they don't own 100% of the intellectual property of the end product and their Chinese manufacturer owns part or all of the intellectual property, the individual cannot legally change factories with the product without a license or permission from the current manufacturer. Once the individual has chosen their manufacturer, a well-crafted manufacturing agreement written in dual languages, English and Chinese, ensures that the manufacturer understands exactly what the requirements are. This agreement needs to be signed prior to the commencement of the individual's product being manufactured. The contract should include provisions such as intellectual property, moulds and toolings, quality, delivery dates, and a damages provision that will convince the Chinese manufacturer that they need to comply with the contract. It must have strict deadlines and it needs to be written in a way that the Chinese manufacturer will fear the penalties will be enforced. If Chinese manufacturers believe their contract will be enforced, they will act in accordance with the contract. However, if the manufacturing company believes no Chinese court will enforce the contract, it will not take any contractual arrangements seriously. For individuals, the key priority in the manufacturing agreement is protecting their intellectual property. If they are investing money into designing and advertising their product, they will need to protect their product, and provisions set out in the manufacturing agreement will allow the individual to avoid issues with their manufacturer relating to the ownership of the intellectual property of the final product. Without those provisions in place, a manufacturer can claim their client's product as their own and will reproduce their client's product on mass scale. The manufacturing agreement needs to clearly state that the individual owns 100% the intellectual property of the final or finished product being manufactured. The agreement should also state that the individual provides the manufacturer with a license to use their intellectual property to only manufacture the product for them and only for the time the agreement is in place. Sadly, too often, individuals have assumed they own all the IP, both in design and branding, and the factory owns nothing. However, this is not the case in China when the manufacturer has used their own technology, mouldings, and toolings to manufacture their client's product, particularly if it's been at their own cost. This results in the manufacturing company asserting that they now own the intellectual property for the final product, either in part or full. The most common outcome is that the manufacturer will continue producing that product under their own trademark as well as selling it to their clients' competitors. A well-crafted manufacturing agreement resolves this issue and makes it absolutely crystal clear who owns what intellectual property in regards to the final product. There are 3 types of manufacturing agreements. The first one is an original equipment agreement, and they are used for individuals who purchase a product from a Chinese factory that is already being manufactured by the factory. The next are original design manufacturing agreements and are for individuals who had their factory do some of the design work for their products. Generally, the individual provides a specification sheet and the overseas factory organises the rest in consultation with the individual. And finally, the contract manufacturing agreement. In this arrangement, the individual has the fully developed product design like a prototype. Under a CM arrangement, ownership may seem simple, but it's actually not, as previously discussed. So how can an individual pursue a claim successfully against their Chinese manufacturing company if they believe their intellectual property rights have been infringed? There are a number of things that are required. A formal relationship between the individual and the manufacturer needs to be demonstrated. The Chinese courts will insist to see properly drawn up written agreements, and the exchange of emails, invoices, and phone calls do not count towards evidence. All contracts must be written in a way that they are enforceable in China. What this means is that the Chinese courts will rarely enforce judgments or laws from other countries. Contracts must be governed by Chinese law, and the governing language of the contract must be Chinese. Chinese courts have been known to refuse to hear cases that involve contracts in a language other than Chinese. Contracts should be enforceable where the manufacturer has their principal place of business, so in that particular district, and litigation also needs to be filed in the district where the Chinese manufacturer has its principal place of business. Chinese contracts are a very powerful tool in the Chinese courts, especially when there are liquidated damages included in the contract provisions. For example, clauses such as if the manufacturer sells their client's product to anyone, the manufacturer will owe the client, say, $100,000. If the manufacturer does not comply with the provisions set out in the contract, the client can go to the Chinese courts and get $100,000 worth of the manufacturing company's assets frozen, and it can happen very quickly, in a matter of a week or 2. So let's recap how individuals can prevent their Chinese manufacturers from selling their product with their brand name on it without their permission and competing with them with their own product. Individuals who manufacture their products in China need to register their intellectual property through the official channels in China. It is absolutely essential, even if individuals do not intend to sell their products in China. Often, creators assume the copyrights or trademarks they've taken out in their own country will protect them in other countries. This is simply not the case because most intellectual property laws are not universal, and the ones that are covered under the Berne Convention have limitations. Individuals need to register their intellectual property in both English and Chinese language spellings. Individuals need to choose a good manufacturer by getting their law firm to complete due diligence on potential manufacturing companies. Under no circumstances should individuals reveal confidential information about their product to any manufacturer without an NNN agreement in place. Individuals should consider implementing a product development agreement, as this stage is the highest risk for the individual having their intellectual property taken from them by their manufacturing company. Before manufacturing commences, a manufacturing contract should be signed by both the individual and their Chinese manufacturer, and it needs to be in both dual languages, English and Chinese. Contracts must have clear requirements for design, manufacturing, pricing, production, and intellectual property ownership, etc. All documents need to be written, governed by China law and in the Chinese language for it to be recognised by the Chinese courts, should the individual need to exercise their rights against intellectual property infringements. Individuals should also invest in intellectual property protection tools to monitor possible infringements. So I hope you found this topic and our 3-part series interesting, and that it clarifies any confusion about what intellectual property protections and contract agreements are required to protect an individual's work when they manufacture in China. The costs involved with having proper intellectual property protection and contracts put in place to protect an individual's work far outweighs the risk of losing reputation, revenue and customers to fakes or to the manufacturers who've taken their client's product. Individuals who fail to register their intellectual property in China and do not have the appropriate contracts drawn up to protect the manufacturing process of their work have no real right to complain about any infringements. The fault lies with the individual. Simply put, nobody is above the law when it comes to negotiating business deals and manufacturing products. When creators hand over their idea or prototype, they are essentially teaching their Chinese manufacturer how to compete with them. This is why contracts are so essential to be put in place so that it can limit what the manufacturer can do. It is perfectly legal for a Chinese manufacturer to copy their clients' products unless there are Chinese registered intellectual property protections or some type of manufacturing contract forbidding it. It is also legal for them to register their clients' intellectual property, including trademarks in China, if the creator neglected to officially register them in China. So the next time an artist tells you that these Chinese companies are hurting their business, you could ask the same reasonable question Mr. Harris's law firm asks their clients. Do you have a written contract or anything else in writing forbidding your Chinese manufacturer from copying your products? The harsh reality is, when individuals do not globally protect their work properly, not only are they hurting themselves, but they are hurting their loyal customers who choose to purchase their products. So if you have anyone telling you that they don't need the types of things discussed in this video series to protect their work, then you know that is where the problem lies. Sadly, many individuals are either uneducated or they have received poor guidance and advice. And don't let anyone bully you for asking these types of honest questions. If certain individuals in the doll community start accusing you of advocating for copy products just because you ask these types of honest questions, then don't listen to that type of nonsense, because it's simply a poor reflection of them. This toxic culture of creating doll wars, bullying collectors and consumers, especially young children, on social media about their doll collection choices needs to stop. It really demonstrates how low certain toxic individuals will go when young children are now being targeted online about their copy dolls. It's such a lowball act to cyberbully children. Both Totty and I encourage our viewers to keep spreading kindness in our community and do not let anyone interfere interfere with your joy that you receive when you have fun playing with your dolls. And a final note to the trolls lurking about on our channel. You know exactly who you are. I can't begin to explain how frustrating it is that you lack the capacity to understand the type of information I share on this topic. It's not my opinion. Laws or legislation are facts, not opinions, and I suggest you learn the difference. In the past, I've had to deal with some misinformed individuals attempting to challenge the factual information I've shared about intellectual property. And I've simply stated, in Australia, the Federal Parliament, in pursuant to Section 51 of the Australian Constitution, is granted power to make laws in respect to intellectual property. If you do not agree with this legislation or the legislation in your own country or what happens overseas in countries like China, can I suggest that you stop wasting your time bullying people online about their doll collection choices and do something constructive like set up an advocate group to lobby your issues with your government for law reform. So that's a wrap, Dolly friends. If you enjoyed today's video, please give it a like because it really helps us out, and we would love it if you subscribe to our channel. So it's back to having fun with our dollies, and we'll see you sometime soon. Love to you all.